My name is Reverend Dr. William J. Barber II, President of the North Carolina Conference of Branches of NAACP, more than 100 branches, the largest NAACP conference in the South, and also the convener of the Forward Together Tomorrow Monday movement. I'm joined here by Reverend Dr. T. Anthony Spearman, who is the pastor in the AME Zion Church, as well as one of the vice presidents for the North Carolina State Conference and a clergy leader throughout the state and the country. We are glad to stand with Representative Garland Pierce, the chair of our legislative Black-Caucus, and the vice chair, Senator Earlene Parliament, and all of these legislators who represent the legislative Black-Caucus, who've gotten on the bus early this morning, just like we got on the Freedom Ride back in the 1960s. We had a Freedom Ride this morning to come to Washington, D.C. in this particular moment in history. We are here today for a day of legislative advocacy. And we're here because we're not unmoved or unmindful of the history of this moment. That's right. 46 years ago, Martin Luther King was killed. He was shot, in much part because of his fight for equality and for voting rights. 49 years ago, we had Bloody Sunday, the march from Selma to Montgomery, which gave us the context to create the legislation called the Voting Rights Act of 1965. We were just there a few weeks ago on that bridge where they were beaten, and I had a chance to speak there with others that were there, and we talked about the fact that it took a bloody Sunday to bring us some daylight on a Monday. We're here 50 years after Freedom Summer, when young people from all over this country gave up their summers, risked their lives to push for voting rights. And we're here 49 years after the Voting Rights Act. So it's clear, we say to the members of the media, we'll say to the legislators today, when we come here this morning, let us be reminded that every privilege we have has come through the blood of the slaughter. Every voting right has come through blood. Every opportunity has come through blood. That's right. And too much blood, sweat, and tears were shed for us to pass in the Congress a voting rights amendment to fix what the Supreme Court debacle of the Supreme Court last year. Any fix that gives us less protection than we had 49 years ago is not a fix, but a failure. That's right. Now, we are glad that the conversation has begun. The NAACP National has been clear about that. It is time for this bipartisan conversation. And this is not a partisan, it is a bipartisan. Voting rights, 50 years ago, it was a Republican and a Democrat that co-sponsored the bill to move America forward. We remember also that Lyndon Baines Johnson said of the 65 Voting Rights Act, Mr. Chair, he said, today is a triumph for freedom as huge as any victory that has ever been won on any battlefield. He also said 50 years ago, there is no room for injustice anywhere in the American mansion. Now, here is our concern. The conversation beginning is great, but the proposed Voting Rights Act amendment relies on a rolling trigger formula that would apply Section 5 pre-clearance requirements to an entire state, including all of its subdivisions, only if there were at least 5 voting rights violations in the state within the previous 15 years, which means it would dismiss all of the other history of discrimination. And at least one of those violations has to be committed by the state itself. Once a state becomes covered, that coverage lasts for 10 years. The bill's definition of voting rights violation that counts toward the trigger is limited, this is a problem with it, to Section 2 and Section 5 court decisions, excluding consent decrees that are already on the books, as well as U.S. attorney objections under Section 5. And they cannot be considered to be covered under pre-clearance until all of the appeals have been exhausted. That's a problem. And then furthermore, in this moment of time when we're seeing the passage of so many voter ID laws that even federal courts now are saying are discriminatory, voter ID, even if the state is found in violation, is excluded as a part of the trigger. Now, we must remember that under the old formula, when those say, well, it puts a burden on states, states could always bail out before. They only had to remain outside of a violation free for 10 years. The problem is no state was ever able to meet that criteria. Today, if Section 4 was in place, as it was before Shelby, the current voter suppression bill in North Carolina that changes 40 different aspects of our voting law, in same-day registration, rolls back early voting, rolls back Sunday voting, disallows out-of-precinct voting, lessens the restrictions on absentee voting, and passes the worst voter ID bill we've seen, worse than Alabama or South Carolina. If pre-clearance was in place, we would not, as advocates, Dr. Spearman and others, be holding in our hands today a 44-page lawsuit that is costing us millions of dollars and thousands upon thousands of lawyer hours to defend rights that North Carolinians have already used. Congress needs to know, in North Carolina, it is not merely that our legislative extremists that are in charge now are denying rights. They are rolling back rights. We already had same-day registration. They're taking that away. We had longer time for early voting. They're rolling that back. They're taking back what citizens of all different races, creeds, colors, and parties have already used. Without pre-clearance, it is left to the advocates to expend money and time and resources to fight, to hold on and defend and expand our rights. If pre-clearance was in place, we wouldn't have to have this 44-page lawsuit.
That's right. That's right.
We wouldn't be in the federal court fighting for an injunction this summer. We would not have the risk of people's rights being violated only to find out 2 years later it was wrong, and then we corrected 2 years later, but the policies that were discriminatory would have been used. That's the danger. And North Carolina passed the worst voter suppression bill after Shelby. We were first out of the gate.
That's right.
First out of the gate. And also, right now, our governor has decided to postpone an election to fill congressional seat District 12. Now, that means that all of the people in District 12 don't have a representative up here. Budget's being discussed today. People in Charlotte, Greensboro don't have a representative. Winston-Salem don't have a representative. We're discussing voting rights. Don't have. If pre-clearance was in place, we could have questioned the governor's decision and asked for a review by the United States Justice Department. So here's our final statement. To suggest that there is not enough racial discrimination in voting or in any other aspect in North Carolina, in Virginia, in Alabama, in South Carolina, where they still fly the Confederate flag, because all these states would be left out. To suggest there's not enough evidence in history to keep those states under pre-clearance is just wrong. And to suggest a voting rights fix that is less than what we won at the Edmonds-Pettus Bridge is wrong. These voting changes needed to be examined on the front end, not after millions have lost their right to vote and have say in the policies that impact their lives. Democrats and Republicans should all be concerned about legislation that removes North Carolina from pre-clearance, because this is what it means, Representative Beard. It means that whoever is in power, and remember, we want pre-clearance even when Democrats are in power. We don't just want pre-clearance from Republicans, we want it for all parties. Because without it, it means whoever is in power could pass voting changes and tactics that would not have to be pre-cleared, thereby shifting the burden onto the litigants to prove discrimination. And so we're calling today, and we're saying that we want congressional lawmakers to take action. Because if they don't, and they were to pass it as it is, they will have made themselves accessories to any future acts of voter suppression passed by the General Assembly that otherwise would have been